it's not our opinion, and I can't agree with my honourable colleague on the fact that this bill fails both, as she said, the rights and the treatment that are available to mental health consumers in this province. As a matter of fact, I would suggest it does exactly the opposite. What this bill is trying to do and attempting to do, and again, as I said, I don't have much time leading up to the moment of interruption, and perhaps I should say for what I'm going to say, continue on for perhaps about half an hour from now, Mr. Speaker. Would you like me to?
I would like you to adjourn debate. Thank you very much, honourable member. We've reached the moment of interruption. The subject of the late debate was submitted by the honourable member for Annapolis, and it reads, therefore, be it resolved that members of this House demand the Premier act immediately to fix the healthcare crisis that he finally admitted existed last night. And I'll recognize the member for Glace Bay. Welcome.
Seems to be my
welcome
day,
to
Mr.
debate,
Speaker.
member.
Fortunately, I was picked for this one as well, Mr. Speaker. Mr. Speaker, I'm pleased to have an opportunity to bring this issue forward for debate. Believe me, a healthcare crisis that we face now. And I was rather shocked when I heard last night that the Premier told members of the Province House Press Gallery, and I quote, that there are a lot of things that I would like to see get done that are not yet done. I think we have to resolve the healthcare crisis, for example. It sort of reminded me, Mr. Speaker, there's an album by Supertramp from back in 1975 that's entitled "Crisis? What Crisis?" And the question posed by that album was probably going through a lot of people's minds last night, Mr. Speaker. After the health accord with Ottawa, after 5 years in government, the Premier finally says that there is a health care crisis. How could that possibly be, Mr. Speaker? There's $1 billion more annually going into health care, and the system is in crisis. Again, Mr. Speaker, how could that possibly be? So I was shocked that the Premier has yet to be called to task for misleading people in this province, because it was during the 2003 election that the Premier and his PR people tried to portray the Premier as a man who lives up to his promises. That's what they said. Back in 1999, it was the leader of the third party at the time, Dr. John Hamm, who told Nova Scotians that health care didn't need more money. But now, after 5 years, Mr. Speaker, and $1 billion, billions, it's just $1 billion later, health care clearly needed more money, but even after all that money is poured into health care, the Premier admits that we still have a health care crisis. Mr. Speaker, it amounts to the Premier breaking his promise. There's something fundamentally wrong with the health system. There's something fundamentally wrong when health care consumes 47% of government program spending, yet we're losing specialists, we can't attract more, the recruitment plan is not working. There is a crisis in human resources in health care in this province, Mr. Speaker, that is unprecedented. So who is to blame? Well, Mr. Speaker, blame is not going to solve the problem. It's time the Premier accepted that he has failed. He has to work on a new plan and a new direction, or else our healthcare system is going to collapse. Mr. Speaker, today in the House, it was the leader of the NDP who brought to the attention of this House that the case of a woman who can't get a hernia operation. Part of the reason, Mr. Speaker, is that there are not enough anesthesiologists to keep those operating rooms running at capacity, and it's causing blockages throughout the system. Well, Mr. Speaker, if we don't address the lack of, for instance, anesthesiologists, the system will be backed up and the cost overruns will be absolutely enormous. You know, Mr. Speaker, our leader has been criticized by the Tory party for supposedly saying that $140 million should be removed from health care to pay for education. Well, Mr. Speaker, that is nothing more than pure fabrication. I said before in this House during a debate, we've got the tape to prove it, if anyone wants to listen to it. It was not said. The reality, Mr. Speaker, is that our leader wants the Premier of this province to live up to his promise to control health care costs and provide for quality health care. Again, Mr. Speaker, in 1999, it was the Premier now, the Premier of the day, or current Premier, who voted against $600 million for health care, and then to proceed to spend the same amount, $600 million. But he spent $600 million plus $400 million more, and now says it's a crisis. Well, Mr. Speaker, the minister talked about a Liberal credibility gap. Well, the Premier, Mr. Speaker, is the one with zero credibility on the health issue. He has sat on his hands for 5 years, and now he tells us health care is in a crisis. He gave his word, and he broke it, plain and simple. Again, Mr. Speaker, crisis. What crisis? The Premier promised that we would have quality health care at an affordable price. And Mr. Speaker, I want at this time to table the State of the Province address from November 1st, 2000. In that speech, the Premier said, and I quote, "Most Nova Scotians also believe the healthcare system can be better managed." Again, they're right. It's wrong that approximately 1 in every 4 Nova Scotians is receiving the wrong type of care. More often than not, a more expensive type of care. Again, that is why we are working to change the system, but it can't happen overnight. Well, Mr. Speaker, no one asked the Premier to do it overnight, but I would think that after 5 years, that's enough time to at least make somewhat of a dent, but the challenges still remain. Again, Mr. Speaker, the Premier has misled Nova Scotians into thinking that he can control health care costs and provide quality care. What we have now, Mr. Speaker, is a crisis. It's a crisis caused by a Premier who simply overpromised and then underdelivered. So, Mr. Speaker, if we want to change the course that we're on, first of all, the Premier has to open up a dialogue. Open up a dialogue so that all parties and all stakeholders can start controlling costs before it's too late. Mr. Speaker, we're very close to it being too late because time is running out. What's being left behind here is not a legacy that we want to leave for our children. It's a rather foul legacy that we're going to leave behind. A legacy of ever-increasing, uncontrolled costs in health care. You know, Mr. Speaker, people liked John Buchanan, the former Premier. They liked him. Nobody ever asked him really, though, a tough question, and we know the result. And it seems, it would appear to me anyway, that the Premier is experiencing a second honeymoon with the media, maybe. He thinks by throwing money around, he'll somehow advance his legacy. By admitting, Mr. Speaker, that there is a crisis in health, we may actually get to the point of finally a reasoned debate. A reasoned debate. But if the Premier refuses to admit his failure, first of all, how can we possibly move forward? Mr. Speaker, it's time that the Premier answered the tough questions, and let's hope that he's going to be willing to do that. When we say crisis, what crisis? It's time that the Premier answered that question as well. The Premier admitting that we have a crisis in health care is a first step, Mr. Speaker, simply a first step. And we have to make sure, now that the Premier has admitted that, I'm glad, I'm happy to see that finally the Premier has owed up to the fact that we do face a health care crisis in this province. We have people who are on waiting lists for a year or more. We have people who still can't get a family doctor. We still have emergency rooms across this province closing on a regular basis, Mr. Speaker. It would be very simple for me to say, and to chastise the Premier by saying, healthcare crisis? Well, duh. Yeah, of course there's a healthcare crisis. And we've known that for some time. But perhaps, Mr. Speaker, the Premier will see this as the first step that's actually needed towards finding some solutions for the crisis that we do face in healthcare. And as I mentioned, the first step would be to take the major stakeholders and consult with them and ask them, how can we improve healthcare in this province? How can we get more for our dollar? How can we make healthcare accessible to each and every Nova Scotian at a cost that won't drive us eventually into bankruptcy in this province? Mr. Speaker, and I thank you for the opportunity to address this resolution.
Thank you very much. I recognize the honourable member from Kings North.
Thank you very much, Mr. Speaker. And it would be easy to mock the Liberal Party and their resolution, because if they ever got in office with the current leader, there would be a crisis, because $140 million would be taken out of the healthcare system. And one would ask rhetorically in each of our ridings where that money would come from. In my own riding, I'd ask, does it come from getting rid of the 21 new acute care beds in the Valley Regional Hospital? Would it come from getting rid of the MRI machine in the Valley Regional Hospital? Would it come from getting rid of the expanded emergency room? And one could go on and on. But I'll treat the issue more seriously than that, because there is an issue here in the sustainability of the Medicare system that we have. We have an aging population, and we know across Canada, and particularly in Nova Scotia, but across Canada, we know that an aging population tend to use the healthcare system more. People over 65 on average go 9 times to the doctor per year, and 1 in 7 Nova Scotians are over 65, and the figure's a little less across Canada, but still there. We also know that we have a population that's probably not as fit and doesn't exercise as well as it should, and clearly that impacts upon the healthcare system and upon the sustainability and use of the healthcare system. In addition, people are demanding a wider range of services. Medical services that when originally Medicare was brought in weren't considered part of the Medicare envelope, but now people expect these services and expect them to be part of the Medicare system that we have here in Canada. I think the role of doctors, when Medicare was made a public system, nonetheless doctors are really private practitioners who bill privately. And so we're looking at that whole system and looking at moving to alternate funding programs, to salaries rather than to fee-for-service as we have now. Another stressor upon the Medicare system that relates to its sustainability financially is the cost of medications and new medications that come out. Medications that are good, that are life-giving, health-giving, and yet that are very expensive. Some medications that we have cost our province tens and perhaps hundreds of thousands a year for one medication. The rising cost of technology is another factor that impacts upon the sustainability of the healthcare system. Many of the machines that will perform the diagnostic tests that are needed are very complicated and very expensive. And the cost of these machines and the new technology continues to go up and up. And this is coupled, Mr. Speaker, with what I see across Canada is a lower tolerance for paying taxes. That people look at the United States and they sort of compare the tax regimes and want to pay lower taxes while at the same time having the same level of service. And it reminds me of a comment my colleague here will turn over in his chair when I quote Bob Rae, the NDP leader. But I think Bob Rae had a very good comment, because he said Canadians want Scandinavian-type services paid for at American-type taxes. You can't have it both ways, Mr. Speaker. But there's another issue that I want to talk about, and I'm going where angels fear to tread, that impacts upon the sustainability of healthcare. And I probably shouldn't touch on this, but I will just very briefly, because I think at heart maybe there's a spiritual problem involved here. And I state that because I see in our society that we've moved away from a position that believed that this life was a continuum and part of a fuller sort of existence. And we've moved away from that to where this life is it, and this is it. And so we're going to grasp and hold on to this as hard as we can, however much money it costs, and at whatever price it costs. We have people who freeze their bodies at great cost in the hopes that sometime in the future some sort of miracle will be discovered that will give them longer life. And I think this inability to face death as part of life impacts upon the sustainability of the healthcare system in a serious way. And that's why I say there's a sort of spiritual problem here at the basis that can't grasp that death is part of life, and that there is this continuum, Mr. Speaker. I know I'm treading on touchy areas here, but I do think, from my own perspective, that there is that. Plus, coupled with the fact that Canadians more and more, I see, are demanding, are adopting this sort of individualistic attitude that I want what I want for myself, and the larger community isn't really that important. So if I can't get this health care, I don't care if it disadvantages someone else. I want it for myself. And that, too, is a spiritual problem as well, I think you'd agree, Mr. Speaker. The loss of emphasis upon the community, upon the person being in community and part of the larger community, I think impacts upon this. And so, as I said, it's a subject that I sort of fear to talk about too much, but I do think I want to put it out there. I remember once I had a discussion with John Ralston Saul about how at the basis of many of the issues in society were spiritual, religious issues, and he disagreed vehemently with me. We were talking about the role of culture, and he talked about how culture was the mirror in which society sees itself. And I asked him what he thought of Paul Tillich, the theologian Paul Tillich's statements that religion is the substance of culture and culture is the face of religion, which is similar to what Samuel Huntington's been talking about in his book, The Clash of Civilizations. And Ralston Saul disagreed totally with me. But I do think that there's something there, that at the basis of many of our problems, be they economic, be they in terms of the sustainability of healthcare, be they education, that there's spiritual problems, a dislocation spiritually that needs to be dealt with. Otherwise, what we'll be doing, I think, is treating the symptom rather than the key problem. And that's, I think, what all the furor and all the activity and all the work in terms of sustainability of healthcare, I think it's treating in many ways the symptom rather than the core problem. But as I said, that's something I just wanted to touch upon very briefly, because it's something I'm still trying to tease out in my own head, how it impacts and what the solution then would be for that, if that indeed is true. If you've read Václav Havel, Mr. Speaker, and I know you're a well-read person, but particularly his latest collection of essays is something I think the title is Politics as if Morality Mattered. Time and time again in those wonderful collection of speeches, and I have enormous respect for Václav Havel, but time and time again in those speeches, which he wrote himself as opposed to most politicians who just read speeches that speechwriters write for them, he talks about how politics needs to be spiritualized. And that the problems that he saw in his country of Czechoslovakia coming out of the totalitarian sort of regime that really at its heart could only be dealt with the politics that was spiritualized. And he didn't mean in a narrow fundamentalist sort of way, which is I think what people hear, and which is the danger whenever one talks about religion in the context of political problems. But he talked about how, and I have this wonderful quote which I wish I had with me, that he gave to an audience in Tokyo about the need. And I think that I just want to end by saying, I'll defend the government. We're doing many things, I think, in terms of the health care system. We could talk about them all. And I have a document I'll table, some speaking notes that I haven't really touched on, because I think they're very good speaking notes. But at its heart, I do think that there's a spiritual vacuum here, which impinges very directly upon many of the crises we face, and particularly upon the sustainability of healthcare. Thank you for the time of speaking.
Thank you very much. I recognize the honourable member from Halifax Needham.
Thank you very much, Mr. Speaker. Well, I would agree with one thing with the honourable member. I think that there is a vacuum, but I'm not sure that we'd agree on the kind of vacuum it is. It's not a vacuum cleaner, though. That's the one thing I can say. I'm pleased to have an opportunity to rise in the House and participate in this discussion tonight. The resolution that was introduced by the member from Annapolis says, therefore be it resolved that the members of this House demand the Premier act immediately to fix the, quote, healthcare crisis, unquote, that he finally admitted existed last night. So I'd like to take a few minutes to ratchet down the rhetoric around healthcare. And I would say to both the government party and to the Liberal Party that we do a great disservice to our healthcare system if we run around talking about a healthcare crisis. And I'd say that to the Honourable Premier as well. We have some serious problems in our healthcare system, without a doubt. Wait times, for example, is a serious problem. But I don't think we do any service to our public healthcare system by crying wolf all the time about how we have a serious healthcare crisis. People who I hear say we have a serious healthcare crisis are people like Preston Manning and Ralph Klein and Mike Harris, and they make this claim and they ratchet up the rhetoric because they have an agenda. And if you read the publication that came from Mike Harris and Preston Manning to every one of us, their agenda is private health care. And their whole argument is that the public health care system is in a crisis, and that's why we need private health care. So I would say we have some serious problems in our healthcare system, but they are not problems that are insurmountable, and they are not problems that we can't solve, and they are certainly not problems that we can't solve within our public healthcare system. Now, we had this debate a couple of weeks ago, well, maybe even last week, I think. And at that time, I pointed out here in the chamber to members that the problems we have in healthcare they have an origin. In 1995, when our current Prime Minister was then Federal Finance Minister, I guess I would say back in the days not only when Paul Martin wasn't the Prime Minister, but when he was still a fiscal conservative, he introduced a budget that initiated a 20% reduction in federal cost sharing or federal financial contributions to health care in this country. Now, if you take 20% of the federal government's contributions to health care out of a province like Nova Scotia, you are, over a 3-year period, you are going to seriously damage the healthcare system. No ifs, ands, or buts about it, Mr. Speaker. And that's exactly what occurred. And how did this province respond? This province responded by, getting rid of nurses, paying nurses to leave the profession, and reducing the number of doctors that we educated in our medical schools, and we stopped purchasing new equipment. There are all kinds of things that occurred. I'm not saying that this government did that. I'm saying the government of the day, a former government, the Liberal government of the day, that's how they responded. That's how they responded. And people said, people at the time said that the harm that was being done would last for a considerable period of time, because you can't turn those kinds of cuts around overnight. Once you haven't trained doctors for 4 or 5 years in the numbers that you require, then you can't have them appear overnight. It's going to take some time. I remember standing in this chamber and asking Dr. Jim Smith, the member from Dartmouth East, I think, at the time, the extent to which this government, or the province of Nova Scotia, lost revenue as a result of the Paul Martin budget in 1995. And he told me that we lost $800 million in federal government funding. Now mind you, that wasn't only for healthcare. As far as I know, it also was under the CHST, and it meant we lost money for our post-secondary educational institutions, and probably under the Canada Assistance Act as well for social programs, housing and what have you. But nevertheless, I mean, when we look at why there has been a huge infusion of money into the healthcare system in the past 3 or 4 years or 5 years, it's because we're playing catch up for all of those years when we lost money. And in fact, I think we're probably not back yet to 1995 levels of healthcare funding from the federal government. I could be wrong on that, but I think that this is, clearly a very difficult situation. And when we had this debate last week, the Minister of Finance, I guess we can't say names, but the Minister of Finance did indicate that in fact that was the case, that we are playing catch up now. So I think it's really important we not be hysterical, and we contribute to this idea that health spending is out of control. I would really recommend that members of the House become familiar with the work of Dr. Robert Evans, who is a health economist. He's actually one of the most senior health economists in the country, very well respected, was at St. Mary's not so long ago to give a very excellent talk on whether or not healthcare is sustainable in Canada. All of his research would indicate that healthcare is, in fact, sustainable. Not that we shouldn't be concerned about how we spend those dollars and doing it in an efficient and an effective way. We always need to make sure that we're using healthcare dollars to get the best results. We have serious problems like shortages in human resources and what have you, but it's not a crisis. And I don't know how much time I have left, Mr. Speaker, but I'd like to give the remainder of my time to my colleague.
Member from Dartmouth North.
Thank you, Mr. Speaker, and I want to thank my colleague for Halifax Needham for giving me an opportunity to make a couple of comments on this particular resolution that's before us this evening. I do know that, Mr. Speaker, that the honourable member from Richmond during question period had asked the Premier then of the day to rein in health care, that in fact there was a crisis in health care and there was a cost. I think it's important for Nova Scotians to know how that cost came about. I happened to come to this Legislative Assembly in 1998, and there was a proposed election and budget in 1999. The then healthcare minister, Dr. Jim Smith, the honourable member for the Liberal Party, proposed a $650 million loan to address the health care issues in this province. Not only that, his government was responsible for running this province from 1993 to 1998. During that period of time, his government turned around and made the significant cuts to health care, in which the honourable member of Halifax Needham alluded to. He is a member whom, in fact, gave the nurses early retirement. And all of a sudden, there was a need and a crunch and a crisis to address the nursing shortage issue. As a matter of fact, there was also a need to bring in some doctor shortage issues as a result of that government's proposal at that particular time during the administration of this provincial government. I think it's for members of that political party to stand up here and to imply that they have all the answers to address the health care crisis and that they're going to get elected in the next provincial election by addressing this very issue. And for their member, Mr. Speaker, and for their leader to imply that there is some apparent surplus of money in the health care budget that can automatically be extracted and channeled into education is absolutely shameful. You're right. Because, Mr. Speaker, the money that is allocated to health care services is what the Nova Scotian public demands. They demand a health care service that is second to none. And Mr. Speaker, I remember visiting my cardiologist at one time, and he said that the health care costs will continue to increase in the province because people expect to live longer, and when in fact they go to the institutions for health treatments, they are there much longer. All those are significant costs, Mr. Speaker, costs in which we have to address because the members of our community tell us that that's the kind of health care service they need. And I would like to remind the honourable members of the third party, Mr. Speaker, that they are partly...
Order. Time for debate is expired in late debate. We resume debate on Bill 203. I recognize the honourable member from Glace Bay.
Thank you, Mr. Speaker. I'm not going to take up too much more time because, as I've stated, it's our opinion, and we feel that we certainly have consulted with the stakeholders here. We've heard from large numbers of people that are affected, from families that are in crisis, from families that are struggling with their loved ones. Those are things that are etched on my mind right now. Story after story after story. That we made a conscious decision to support this Involuntary Psychiatric Treatment Act. And now, Mr. Speaker, I would make somewhat of an impassioned plea to the New Democratic Party of Nova Scotia, that if you really want to hear from the people of Nova Scotia, if you really want to hear about this act, if you are really concerned about the well-being of mental health consumers in this province, then obviously the thing not to do right now would be to stall this legislation by putting up speaker after speaker after speaker after speaker in second debate, and to stop this legislation possibly from moving forward to law amendments and from possibly moving forward and being passed in this legislature. That would be my plea to the NDP. After I sit down, that they would not, and we are prepared, Mr. Speaker, we are prepared to stay here until the cows come home, if necessary, to pass this piece of legislation. That's how important it is to Nova Scotians. This piece of legislation is too important to play politics with. It's too important to play politics with. And all that will be played here today, Mr. Speaker, is politics because of the fact that the government has brought forth a piece of legislation that we are supporting. What will happen now is the New Democratic Party will put speaker after speaker after speaker in their place to try and stall this legislation, to stop it from getting to one of the most important committees of this legislature, that being the Law Amendments Committee, to hear from the people of Nova Scotia. Who we would hear from in that committee are mental health consumers, their families, from psychiatrists, from patients. We would hear from everyone in Nova Scotia because I'm sure the NDP knows that there are people lined up to both oppose this bill and to speak in favor of this bill. And I personally would like to hear from them. And the place that we do that in this legislature is not with members of the Legislative Assembly standing in their place hour after hour, wasting and killing time for one purpose and one purpose only. And I don't mean that to be derogatory. I don't mean it to be derogatory. What we do here is very important, Mr. Speaker. What we do here is very important.
Order. I recognize the honourable member from Dartmouth Cole Harbour. Cole Harbour, Eastern Passage.
You know, Mr. Speaker, I stand here on a point of privilege because that member is saying that we, as members of this House, are elected to have the right to speak on legislation. That is an absolute fundamental right of being a member of the legislature in this House. That's what it means to be part of responsible government. And yet this member stands up and accuses us of not being able to use our right to speak and says that it's time wasting. Well, I'll tell you, Mr. Speaker, this is not time wasting. This is us debating legislation. That's what we're here to do, and we're going to keep doing it.
I recognize the honourable member from Glace Bay.
Mr. Speaker, obviously I've touched a nerve, okay? I did not say what we do here. Of course, what we all do here is of course it's important, Mr. Speaker. What I'm saying is the game, the political game, that unfortunately will be played from this point on with this very important piece of legislation, and there are going to be people who are going to be hurt, and hurt seriously because of the fact the New Democratic Party will now stall this piece of legislation. That to me, Mr. Speaker, is perhaps, it's just not the right thing to do. So what I did by starting out my next line of thinking was to make an impassioned plea to the NDP not to do that and to move this forward to the next stage, which is to hear from the people of Nova Scotia. Now, what could be more important than to hear from the people who are directly affected by what we're doing and what we're speaking of right now? And I'll agree with the member from Cole Harbour Eastern Passage. I'll agree with him. But I want to hear from them. I want to hear from them, and I want to give them the chance to come to Province House and to tell us their stories. And if the members would hear from them, I think it would be far more important to us to finally make a decision, a reasoned decision, after we hear from the people who are most directly affected. And Mr. Speaker, that's my plea to the New Democratic Party. I don't think for a minute that they'll take me up on it, but I hope they do. Strange things happen in politics. Who would have thought Belinda Stronach would be a Liberal after today? So I'm hopeful that even something as strange as that can happen, that the NDP will say, you know what, the member from Glace Bay made sense. And when I sit down, I'm hoping they're going to say, let's move this on to the Law Amendments Committee where it rightfully belongs, so that we can hear from the people directly affected by the legislation that we are proposing go through. Thank you very much, Mr. Speaker.
Thank you. I recognize the honourable member from Halifax-Shubucto.
Thank you very much, Mr. Speaker. Politics, I guess, makes strange bedfellows, but I think I'm going to give a pass on the invitation from the honourable member who just spoke to join up with him in any way at all. Mr. Speaker, I had occasion recently to review some statistics. The statistics I reviewed are issued by our provincial government, and they set out causes of death. And they're part of the general array of statistics on birth and illness and so on. And I hope members are familiar with the stats I want to speak to in starting. Because what I found was that every year in Nova Scotia, there are 7 or 8, some years 9 or 10 people who are killed through murder. And this is a consistent number over the last 5 or 6 years. And every year in Nova Scotia, there are maybe 10 or 12 people who die on the job. And this number, too, is a consistent number. But every year in Nova Scotia, 100 people commit suicide. That's 2 people every week kill themselves. And that is a consistent number over a period of years. Now, we spend, of course, a lot of our resources and a lot of ink in the press when someone is murdered. And we spend a lot of resources focusing on injury and death on the job. But it's not so clear that we spend as much attention and resources as we ought to dealing with problems of mental disorder, particularly those that are so serious that people kill themselves. And I'm sure that it has been a fact of life for every member in this House that we know someone, family or friend, who has committed suicide. You probably can't get to be middle-aged, as most of us are, without having experienced that in some form. And at the time something like that occurs, family and friends come round and they try to figure out what happened. And they compare information and they compare notes and they pool their information and they try to see who knew what clues were there. Did we know about it? Was this person under treatment? If so, what kind of treatment? Could we have done something? Could we have done something earlier if we knew? It's a very difficult circumstance. And when it does happen, it sometimes even has an unfortunate knock-on effect. And by that I mean that a fact of suicide, once known, becomes a temptation for people who are close to the person who committed suicide. They begin to ask themselves, why not? Maybe I should do this too. It's unfortunately almost catching. And we see, particularly, I think, amongst teenagers sometimes, instances of multiple suicides. And what becomes apparent to people who have to deal with this is that when they think about it, they realize just how common it is, and they realize often that this wasn't the first example that they've encountered in their lives. And they talk with their friends and they realize it is widespread. It is a problem. And again, they ask themselves correctly, what could we have done? What could have been available for people who are in that bad a state? Now, suicide, of course, is one of the most dramatic forms and manifestations of mental illness. And I was particularly happy to hear in the comments of my colleague from Halifax Needham earlier the reminder to us that the idea of dangerousness on the part of those who have mental disorders is usually a profound mistake. If dangerousness exists with respect to people who have mental disorders, it's usually self-directed. It's usually the case that it's suicide, not that it's a threat to others. And even then, it's a rarity, but all too common. The starting point, therefore, to my mind, is that we have to recognize that problems of mental disorder, in greater or lesser degree, are commonly encountered, and we have to deal with them. And I want to say to my colleague from Glace Bay that this bill may pass in due course. And we're not here to try to obstruct the bill. In a minority situation, the government, of course, cannot on their own force a bill through the legislature by waiting it out. They require the agreement of at least one other party. We've heard, And we heard in advance of the debate from the third party that they were prepared to support the legislation. In those circumstances, I'm assuming that sooner or later this bill will become law. Therefore, our obligation and our mission is to put on record the problems that we have with this legislation, to go on record so that no one will be misled. No member of the public should be misled into thinking that this bill is going to be a useful piece of legislation in dealing in any serious way with that sector of the healthcare system that focuses on mental disorder. Now, I have a number of criticisms that I want to make about this bill. You won't be surprised to hear that in many respects they parallel the comments that were made by our health critic, the member from Halifax Needham. She focused on a variety of things that the bill failed to do, and she began to touch, near the end of her remarks, on some of the legal difficulties with the bill. So to a certain extent, I'm going to maybe try and start with some of the legal difficulties with the bill, so that we make sure that these points are put on record and are as clear as they can possibly be. And there's an abundance of problems with the legal side of this bill. But before I engage with the details of that, I want to explain my interest and my background, and to a certain extent, a limited extent, my expertise on this. My colleague from Needham has expertise as a social worker. She has dealt in her professional life with people who are in need of these services. So too have I in my professional life as a lawyer, and I've also dealt with psychiatrists by giving them legal advice. And I want to review this, although not at too much length, to explain how it is that I came to have an extensive involvement in questions having to do with law and psychiatry. This goes back to the first couple of months after I was first admitted as a member of the bar. Mr. Speaker, that's more than 30 years ago now in Nova Scotia. I was only a month or so at the bar when someone I knew suffered an acute psychotic episode and ended up in the Nova Scotia hospital. And this man, who was in his mid-20s, was being given ECT against his will. ECT is electroconvulsive therapy. That is to say, shock treatment. And he didn't want it. And he managed to phone a friend who got hold of me, and I knew this fellow, and I went over and I spent time talking to him and to his psychiatrist. Mr. Speaker, I was probably no more than a month at the bar at that time. If you are a lawyer, his psychiatrist said to me. I was very young. Well, we had a discussion, and I'm happy to report that she, his psychiatrist, knew a lot more about the law having to do with psychiatry than I did. And she pointed out to me that there had been extensive litigation in recent years in the United States about the rights of psychiatric patients, and she pointed me in the way of some literature, and I started to read. And I began to learn about law and psychiatry. On behalf of my friend, I went to court, to the Nova Scotia Supreme Court, in an attempt to obtain an injunction to stop the giving of the ECT. Now, the statute that was in place at the time was a predecessor to the statute that we have in place now, but essentially had the same title. I think it was the Hospitals Act. It was before some subsequent revisions. It was even a cruder act than the one we have now. And I pointed out to the presiding justice that there was a difference between being able to detain someone if, as a result of their mental illness, they were a danger to themselves or others, and being able to treat them without their consent. I said that there was a distinction to be made between detaining someone and respecting what could still be their civil capacity. I said there still had to be an assumption that civil capacity survived involuntary detention. And that if doctors were of the view that someone was not civilly capable, there was a process in place, separately under the law, to appoint a guardian who could make health care decisions. What's the point, the judge said, of being able to detain someone if you can't treat them? Now, when I began subsequently, and he didn't grant an injunction. However, I'm happy to report that upon discussion with the hospital, they agreed to stop the ECT. That's what happened with my friend. Longer story, but that's all we need to know for now. But when I went away and started to read, I realized that the American law had recognized this distinction. And by the American law, I mean litigation, I mean cases. I mean that people had gone to court and established under the American Bill of Rights their entitlement to a presumption of civil capacity, and that it had to be viewed as distinct from any state-mandated opportunity for detention. So I began to learn about this. And I then went on to take up my first real job as a lawyer. Mr. Speaker, that was in Ottawa with the Federal Department of Justice. An employment circumstance I'm sure you know. And the Department of Justice does a variety of things. One of the things it does is it assigns lawyers to be in-house legal counsel for other government departments. And I was assigned for 3 years to be one of the in-house legal counsel to the Solicitor General's Department. And the Solicitor General runs the penitentiaries, it runs the parole board, and it runs the RCMP. And part of my job focused particularly on the penitentiaries. And one of the main users of my legal advice during those 3 years turned out to be the psychiatrists who worked in the federal penitentiaries. They wanted to know what they could do. They wanted to know about the mental health legislation in place in Ontario and in the other provinces. During those 3 years, I probably visited almost every federal penitentiary in the country and dealt with all the officials who ran the penitentiary system and extensively got to know the psychiatrists. I had, perforce, to learn a lot of law about psychiatry. I was greatly interested in it, and I put together a course, which I subsequently taught on this subject. I've taught it in Ottawa. I've taught it at Dalhousie Law School when Professor Archie Kaiser, who normally teaches that course, was away on sabbatical. And I have given a number of seminars over the years to psychiatrists and to psychologists on the law and psychiatry and the law and psychology. And after I left the Department of Justice, I went to Toronto, where I was teaching law. And during that time, I was a volunteer for the Canadian Civil Liberties Association. I worked with Alan Borovoy, their General Secretary, who at that time had a particular interest in revising Ontario's mental health laws. And the CCLA, under Mr. Beaurevoy, did a very interesting thing. He looked at those certificates that are supposed to be signed by doctors in order to commit people involuntarily to hospital. And he got hold of at least 200 of these certificates, or the certificates bearing on 200 patients. And he took them to 3 or 4 very senior litigation lawyers in Toronto. And he said to them, read these certificates. And he said to them, tell us, if we were to go to court and challenge these certificates, what would be the result? And the lawyers that he consulted uniformly were of the opinion that about 75% of those certificates would be set aside upon judicial review by a court because the dictates of the statute had not been followed by the physicians who were filling them in. Many of them had gaps. Many of them simply hadn't answered the questions that they were supposed to answer in the forms. Many of them were written in language that didn't correspond to the statute. Many of them were written in language that simply wasn't clear. Many of them weren't signed. If you go back and you check, I think the front page of the Globe and Mail for sometime in 1977 or 1978, there's an article to be found reporting on this. This focus of publicity on the inadequacies of the system at the time was combined with a brief that I wrote on behalf of the Canadian Civil Liberties Association that was submitted to the Minister of Health for Ontario that pointed out the inadequacies of the legislation and made suggestions for change in Ontario's legislation. This worked, and the Ontario government began to revise its legislation. I'm happy to report that I escaped Toronto and came back to Nova Scotia for a number of years, but found myself again in Ontario from 1984 to 1988. And during that time, the Ontario Ministry of Health was engaged in another round of revisions of its mental health legislation. And I sat on a committee that met every Tuesday night for 2 years as a representative of the Canadian Civil Liberties Association to revise the mental health laws of the province of Ontario. And on that committee were representatives of the Ministry of the Attorney General in Ontario. There were psychiatrists in private practice. There were advocacy organizations who represent consumers of mental health services. There were social workers. It was a serious committee that did serious work and resulted in the revisions of the laws of Ontario. I apologize for this long excursion, but I wanted to make it clear that although, unlike my colleague from Needham, who has engaged as a social worker and has actually met and dealt with many of the consumers of mental health care services, my knowledge has been of a slightly different sort. It's been focused on the law. And I've come to the point of thinking that at this juncture, I know a fair bit about mental health law here in Ontario and elsewhere in Canada. And although I certainly agree with my colleague from Needham that absolutely the biggest need, the most important need of our system is for adequate community housing with supervision where needed. And that must be absolutely the starting point in looking at the array of services when we consider prevention, when we consider other forms of services, nonetheless, we have to turn our minds as well to some of the legal difficulties. And just as a point linked to this, but which I don't think I've heard mentioned yet, when I speculate about why it is that the third party might be considering supporting this legislation, I wonder if somehow it has to do with the fact that some extra money has been made available this year for services. I have to say that although this is a good thing, we shouldn't lose sight of the fact that 1 year of a commitment of money is only 1 year, and it's not clear that it'll go on forever. And it certainly doesn't offset any of the legal difficulties with the bill. So when I start to think in a civil liberties sort of way about this bill, I find myself compelled to ask, in part, whether it'll do the job, and in part, whether it's susceptible to abuse, and in part, whether the right tests have been put into the legislation. And since I spent some time talking about my unfortunate friend who had been committed and then treated without his consent, on the legal points, I think I might start with that one. Because the definition of the criteria that have to be considered by the psychiatrists who are moving towards involuntary admission have now been expanded. And they've been expanded in the following way. The definition of what is appropriate or what is a trigger allowing for involuntary admission, this is in Clause 17, says that as a result of the mental disorder, the person does not have the capacity to make admission and treatment decisions. Now, this is new. That wasn't in the legislation before. So what is being said here is that not only does a person have to have a mental disorder, not only does that person's mental disorder have to lead to some kind of threatening circumstance, a danger to themselves or others, not only does the person need treatment in a facility and isn't suitable as an outpatient, but in addition, as a result of the mental disorder, that person does not have the capacity to make admission and treatment decisions. Now, you know what that means? It means that those two distinct questions, whether someone should be detained in a hospital and whether they then have the capacity to consent, have been melded together. And the question of an independent determination in a separate process of that person's ability to consent no longer arises. And it no longer arises because the determination has already been made by the psychiatrist when they decided that the person was suitable for involuntary admission. It was already determined right up front. Not by a separate process, not in court, none of that. It was determined already by the psychiatrist as part of the admission process. And this is the focus of where civil liberties and civil rights inside the mental health care system took off when this legislation first, when these circumstances first started to be litigated in the United States in the 1960s. Do you know why there is such extensive deinstitutionalization? Do you know why it is that people who have mental difficulties are not in institutions, but in fact are on the street? It's not because of a change in philosophy amongst those who are in charge of the mental health care system. I mean the physicians. Although there have been changes, of course, in their philosophy over time. But what led to deinstitutionalization was litigation. It was extensive litigation in the United States in which people found that the mental health laws of states all across the United States were deficient by the tests of constitutional liberties set out in the United States Bill of Rights. And when they began to start litigating this, thousands of people were let out of psychiatric care facilities all over the United States, and Canada followed up. And that happened 30, 35 years ago. And we have been struggling for 30 or 35 years to put in place what should have been put in place immediately at the time, that is to say, care facilities for people who didn't need to be institutionalized, but who could exist in the community if they had some supports in that community. That sometimes meant a little money, sometimes it meant a place to drop in, sometimes it meant shelter, sometimes it meant shelter with supervision, but it's been one of the great failings of the North American healthcare system over the last 35 years that, faced with clear court decisions, the system didn't really respond. And what is this bill that's in front of us except yet again a failure to respond? It tries to tinker with the law instead of engaging with what it is that people really need. So when I see a clause, subclause, like the one I just read out, that somehow attempts to go back on 35 years of legal history, not only is it wrong that it should be there in terms of policy, it's just wrong in terms of the law. It shouldn't be there. And it's not that this stuff is not litigated in Canada anymore. It is litigated in Canada now. There are cases that have just been decided in March. One case went to the Supreme Court of Canada from Nova Scotia, just in March. It was called JJ versus Nova Scotia Minister of Health, a March 18th decision of the Supreme Court of Canada. Someone said, what year? This year. March 18th, this year. Can I read to you from Justice Abella's decision? Paragraph 23, quote, "The significance of independent judicial review of state action when a vulnerable adult has been deprived at the instigation of the state of the right to function autonomously cannot be overstated. The court's statutorily assigned supervisory role emerges from the adult's vulnerability. The corollary of a judicial determination that an adult is in need of protection is a corresponding limitation on that adult's autonomous decision-making and liberty. It is the function of the court to monitor the scope of that limitation." What the court is saying is that it's a serious matter to take away someone's liberties, and that the courts are prepared to step in, if necessary, in order to deal with review. And yet, how easy is it going to be for someone to get the ball rolling and get their case in front of the courts? I want to remind the members of the set of circumstances that I outlined for them from the autumn of 1973 when my friend was in the Nova Scotia hospital. He managed to get a phone call out to a friend who got hold of me, and I went over there. Now, it happened that I met this person. I had known this person before, and I was able to come and say, I'm their lawyer, let me talk to them. What's contemplated in our legislation? What's contemplated in this bill? Is there anything there that says, as there is if a person is in a police lockup, they have a right to phone calls? How do they contact anybody? Where's that in the legislation? Who's to know that they're in there? Now, there's a patient's advocate and there's a review board. That's fine, but you know what? It isn't enough. Patient's advocate, review board, it's not enough. It has to be specified that the patients have the opportunity and the right to make contact with external people. If not, we're dealing with the indicia of an authoritarian society that if we saw it in North Korea or China or Nigeria, we would look at it and say, this is too typical and wrong. And I mention those examples deliberately because there are countries that in history have abused the tag of psychiatric illness for political purposes. Let us not forget. This has happened. So what this bill does say is that patients' rights can be specified by regulation later on if the cabinet decides to do that. Well, you know what? It's not good enough. I don't find that acceptable. It's just not good enough. If we're going to take seriously and recognize that there is a loss of liberty for people that we are prepared to sanction by law, we have to make sure, we absolutely have to make sure that there is a way for them to access supports that they might feel comfortable with, that they might want. And this is because they should be able to refuse or engage with a process of oversight through the courts if they want to do that and can find people to represent them. Now, I said that there were recent cases. Not only is there that Supreme Court of Canada case that was decided in March, there's a case that was decided March 30th, again 2005, in Saskatchewan. It's called the Saskatoon Regional Health Authority versus AB. Justice Kruger, in that case, said as follows, quote, "The right to refuse unwanted medical treatment, even treatment for mental illness, is fundamental to every individual's dignity." And that was not a novel proposition in this single case. In arriving at that conclusion and laying out that proposition, Justice Kruger was relying on the 2003 decision of the Supreme Court of Canada in Starson versus Swayze. These are not novel propositions. They are not confined to the United States. They, in fact, have been litigated in our country in as high courts as the Supreme Court of Canada on several occasions. And I think we are going entirely too far in this legislation in several respects. So I've identified what I think are two legal defects so far. One, I've said, is the wrapping up of this question of incapacity to consent to treatment into the test for involuntary committal. And that's a very important one. There is another that I want to flag for you as well. And it has to do with the problem. Now, I'm not suggesting this is necessarily a legal difficulty the same way the others are, but it's certainly a policy difficulty, and one that we all might want to think long and hard about. And it is the fact that the definition of mental disorder now will extend to circumstances of deterioration of mental powers. And this appears in the definition of mental disorder. And that definition, I'll remind you, is stated to mean a substantial disorder of behavior, thought, mood, perception, orientation, or memory. It's memory that I think is really the new feature here that we all have to think long and hard about. This means that your parent, as they get older and begin to have problems with memory, can fall within that definition of a mental disorder. Now, I find that highly problematic. And I think that for the minister to have brought forward this bill for the second time, really, without trying to debate or engage on this issue and say to us why he thinks that this is a good policy choice, is highly problematic. Should that be our policy choice? Is this where we want to go as a society? We're an aging society. Are we now going to be saying our 70-year-olds, our 75-year-olds, when their memory begins to get a bit shot, not clear that everything's completely okay, that they're going to be candidates for involuntary admission to hospitals? Never mind whether the facilities are there. I mean, it seems to me they're not going to be for people in those numbers. But why should it be part of this definition in the first place? So this is really greatly problematic. Next, I want to turn to another legal problem. And in part, this is a factual problem. In part, it's a medical problem, but it's also a legal problem. And it has to do with the fact that, again, the test for involuntary committal, for involuntary detention, turns on the notion of dangerousness. Even though slightly different words are used, it's the question of dangerousness to self or others. And most studies have shown that psychiatrists can't predict dangerousness. So built into this definition is an assumption that the medical profession can do something that in fact tests show they can't do. Now, you'll recall what I said earlier about the kinds of psychiatrists that I was dealing with. I was dealing with the psychiatrists who worked in the Canadian penitentiaries. In fact, I should have pointed out as well that in those years when I was working with the Department of Justice, Canada still had capital punishment. And one of my responsibilities was to keep track of what were called the capital cases, the people who were on death row. And I drafted the reports to Cabinet, the federal Cabinet, on whether those sentences ought to be commuted to life imprisonment or not. And as part of that responsibility, I had to hire 2 psychiatrists to go and talk with the people who were on death row and write reports for me that I could review to see whether there was anything there that was of use. I mention this because part of what I had to focus on when I was dealing with the law of psychiatry was the law as it applied to psychiatrists and their ability to predict dangerousness. And every study that I read indicated that psychiatrists weren't all that good at predicting dangerousness. No better than anybody else. Sometimes worse. I remember quite vividly the first study I encountered. It was called On Being Sane in Insane Places. And what had happened was that researchers had put into psychiatric hospitals in California people who were completely sane. What they did was they had them fake some symptoms in front of doctors, inducing the doctors to sign certificates and commit them to the hospital. And then, having faked the symptoms, they then dropped the symptoms entirely, never reported them again, behaved as they normally would from day to day, but in the psychiatric hospital having been committed. And you know what? In not one case did the doctors figure out that these people were faking. The other patients figured out that these people were faking, but the doctors didn't figure it out. That was the first study I looked at. It's known as the Rosenhan study. Quite a famous article. But it's not the only one. And not just that kind of experiment, but other kinds of experiments and tests and pieces of research have been done, and the facts just don't support it. I had occasion just yesterday, to be reading one of the main Canadian textbooks on criminal law. Don Stewart, professor at Queen's University Law School. Canadian Criminal Law, a treatise, 4th edition, 2001. And I looked, because I had something else I was looking for, at what the current state of the knowledge was, according to Professor Stewart, about criminology and about psychiatry on the issue of dangerousness. And you know what? It's exactly as I remembered it from the last time I looked it up 20 years ago. It's exactly the same. All the up-to-date studies still say psychiatrists are no good at predicting dangerousness. And yet we're building into this statute that test on a gratuitous hypothesis. How can we do this? How can we think about doing this? And what has the minister said about it? Nothing. Nothing. And what about the old test of imminence for another legal problem? The test of imminence, that is, imminently about to harm themselves, imminently about to harm someone else, doesn't seem to be there. It's gone. So when I look at all of the provisions of this bill, even though it may pass, because so far as I can judge, based on the comments of the member from Glace Bay, he doesn't seem to want to take the trouble to turn his mind to what's in the bill. I heard a lot of bluster. I didn't hear any analysis. No, I don't think that's good enough. It's not good enough from the government for this bill. It's certainly not good enough from the third party when it comes to thinking about what it is that's needed in our society for a group of people who are certainly in need. We should not mistake the passing of laws for doing something effective. In some circumstances, passing a law is the right thing to do. In these circumstances, we don't need this law. We can live perfectly well with the statute that we have now, as glossed by the courts when they apply the Charter of Rights and fundamental freedoms. And I want to again emphasize that when we as a chamber deal with a piece of legislation like this, there is enormous potential for families who are out there to walk away with the impression that something serious is being done to help them. The families of people who suffer from mental illness, of whatever category or degree of intensity, are inevitably very concerned. I know from people I've met and dealt with in my constituency who have had children, teenagers, adults, that they have been concerned about, that they do as much as they possibly can to try to find help for those vulnerable members of their family. And they are looking for the government to do something effective. And when they hear that there's a new statute, when they hear that there's a new bill that's coming forward, an act respecting involuntary psychiatric treatment, even though the title now has a more focused and perhaps slightly more accurate name to it, they mistakenly get the impression that they're going to benefit. They mistakenly get the impression that more resources will be available for their families. And it's just not the case. It's just not there. That is why it is that there is nothing that can really persuade us, at least nothing that we've seen so far, that can really persuade us that this bill is worth supporting. Now we have to ask ourselves, and I'll raise this as one final legal point, whether in and of itself it's discriminatory against someone on the basis of mental illness not to make services available. We make services available aplenty for people with other forms of health problems. And yet, looked at objectively, there is an enormous failing and an enormously disproportionate failing when it comes to people in need of mental health supports and treatments. And we have to ask ourselves whether one day there isn't going to be a lawsuit based on that kind of allegation of discrimination, that the system failed to deliver the services that should have been available in an appropriate level for people in need. So, with that, Mr. Speaker, I hope I've set out most of the reasons why it is I find this bill to be highly problematic. It's highly problematic because of a number of legal points. It's highly problematic because of policy, and it's most problematic because it simply is the wrong measure. Something else should be done, but not this. Thank you very much for the opportunity to speak.
The honourable member of Dartmouth East. An introduction? Yes.
Yes. In your gallery, directly in front of you, this evening are some people that have come in from Antigonish, and it's a group from Williams Point, and their spokesperson this evening was Jim Boudreau, and they're all very concerned about a flooding issue in their neck of the woods and the infilling that is going on there, and they would like to see that stopped. And they're here this evening to see if they can get some attention from certain politicians on that they'd like the infilling to stop until there's a study done. And they're very concerned about not just the environment and the concerns for themselves and their own homes, but also for the future people that may live there. And thank you, Mr. Speaker.
Thank you. Now member for Dartmouth North.
Thank you, Mr. Speaker, and I too want to recognize the special guests that are with us this evening. And Mr. Speaker, I want to speak to the bill that is before the House, Bill number 203, an act respecting involuntary psychiatric treatment. Mr. Speaker, I want to say that I was actually impressed with the speak of both the honourable member from Halifax Needham and her expertise with respect to this very issue around social work. I also want to acknowledge the honourable member from Halifax Shabakto, who certainly put the legalese in the context of this bill before the legislature. I only wish that one could articulate that kind of legalese to my community. But, Mr. Speaker, I think it's important also to recognize that the honourable member for Glace Bay, who has made comment to this particular bill, has had the opportunity to speak on this bill and to give this legislative assembly the reasons why his party and he is supporting the piece of legislation going forward. I want you to know that the honourable member has made comment with respect to we as the official opposition just simply speaking briefly on this bill. As a matter of fact, he had even recommended that we would not speak on this bill, that we stop the conversation with respect to the debate on this bill so that it goes across this legislative floor to the Red Room, and then we listen to the individuals whom in fact are going to be the presenters to this bill and the individuals whom in fact he had indicated supported this bill. Although the honourable member also recognized that there will be people who will be coming to law amendments who will be speaking against this bill as well, or anticipates those individuals speaking against the bill. And it's very important to hear both sides of legislation, Mr. Speaker, but it's also the right of the members of the legislature in here to debate this piece of legislation so that the government and its members understand the position that is taken by the official opposition with respect to this bill. I also want to say, Mr. Speaker, that we have talked about, and I do know that my honourable member from Halifax Shabakto had mentioned that, in fact, we came about in deinstitutionalizing individuals with mental disorders some 30, 35 years ago. I do believe that it occurred in 1966 in the province of Nova Scotia, and we recognized deinstitutionalizing persons with mental health orders was significantly important, because prior to deinstitutionalizing individuals, we did have a process of certification. We did have a certificate process. The process that many people can remember was a process where you could be the judge of an individual's competency and automatically sign the individual in. It was a relatively easy process at that time, and we had found that many individuals whom in fact were in institutions ought not to rightfully be there. Mr. Speaker, there was also the perception that individuals who had physical disabilities for some apparent reason were also individuals who had intellectual disabilities or mental disorders. That was proven not to be the case, and many individuals found themselves into institutions. The unfortunate part of this bill, Mr. Speaker, is that it doesn't address the woefully inadequate level of services that are provided to mental health consumers. And before I go into that direction, I do want to say that the government commissioned a report called the Dr. Kendrick Report, the Kendrick Report. And in that Kendrick Report were a number of issues to address the mental health situations in this province. The Dr. Kendrick Report made a very specific request to the government, and one in which the government could have introduced, but chose not to introduce. And that report that in fact the Kendrick Report had suggested to the government was a blue ribbon committee. the Blue Ribbon Committee would in fact be responsible or would have the responsibility to look at mental health issues and to address the appropriate resources and programs and services that should be delivered to the mental health consumers in this province. I remember this government trying extremely hard and has succeeded, I believe, in bypassing the number of 47 different agencies and organizations who had belonged to the Kendrick Group and adopting that recommendation. I want to say that the recommendation would have been one that would have guided this government towards the piece of legislation that we see here today, Bill number 203. I'm sure that the minister who introduced the bill had indicated that he had talked to some 200 stakeholders across the province, and that there were people who support, and there are people in the community who support this piece of legislation. I can also say to you, Mr. Speaker, that had that committee been formed, that this province would have been much better off, because that committee would have sought input by the number of the 47 different agencies and groups that in fact were a part of the Kendrick report. It was difficult for the individuals, because they had felt that when the government commissioned the Kendrick report study, that they would at least adopt the recommendations, and that they would at least listen to Dr. Kendrick's recommendations and hopefully adopt those recommendations. I just want to say, Mr. Speaker, that part of the problem is the lack of facilities and resources. It should be known that the Department of Community Services certainly has created a problem here by placing a moratorium on small options homes and supervised apartments. And Mr. Speaker, I think it might have been just around your time coming in here when in fact, when there was an issue as a result of a very serious incident in a small option home in Dartmouth. And that was it's a well-known problem. It's a well-known I should say, Mr. Speaker, it's a well-known case. And the case was the Eddie Albert Shepherd case. And when we first got elected this legislature, there was a tremendous cry by a number of individuals, including myself, to have a judicial inquiry into why this issue had occurred. And as a result, why this murder had occurred. And as a result, we had continuously, I know for at least approximately 2 weeks during question period, asked this government to provide to the family a judicial inquiry as to how this murder occurred. The government recognized there was a need to look into this issue, and although there was not a judicial inquiry, there was an inquiry into the case. And it's important to know that at that particular time, the government decided that there ought to be a moratorium on small options homes and supervised housing units, particularly known as supervised apartments as well. And the status of that has never come to the fore. The government has chosen not to increase the number of beds in small options homes or in supervised housing units. As a matter of fact, what the government is doing is actually decreasing the number of beds in small options homes and supervised units. For example, Mr. Speaker, I've had a family who called my constituency office on a very important issue with respect to their son, and they certainly knew that it was not possible for them to manage the son in the home environment. And what they wanted was to be able to talk to the government and ask the government what kind of services were available to the family and what sort of resources might also be available. And they had asked for to have a placement in a small option home or a supervised apartment. The individuals were told that there's approximately a 2-year waiting list. A 2-year waiting list for individuals with mental health disorders to enter a small options home or a supervised housing unit. Now, Mr. Speaker, that says something about government and the delivery of the program and services that is needed to help our mental health consumers, particularly those individuals with mental health disorders. The very first thing we tend to do here, Mr. Speaker, is we tend to find the path of least resistance. And if by crafting a piece of legislation that offers one the right to write a certificate, and that certificate being approved, and then putting an individual in a mental institution rather than because that individual may have acted up, then that, Mr. Speaker, is a very wrong direction. I've heard about individuals because they haven't taken their medication, having caused very serious problems within the family unit, situations in which they can't handle, and individuals who are not taking their medications and refuse to take their medications, and the family having difficulty addressing these issues. I don't particularly think that you address these issues by legislation. I think that what you do address these issues by is having the resources, the expertise available through government to provide those families with the need to address those very important issues. I also had the experience of Mr. Speaker, a community calling adult protection on an individual. And adult protection comes in, and when they do the assessment, there's an assessment that that states that the individual in question must be causing harm to themselves or harm to others. And often there's an evaluation and an assessment. And right now, without this legislation, there's a reluctance to institutionalize individuals unless it's absolutely necessary. Mr. Speaker, I think that when we craft legislation, we need to take that kind of thinking into mind. We need to know that this piece of legislation must be absolutely necessary, and that it must meet the test of time. And it also must meet the test of helping the individuals who the legislation is intended to help. Now, I do know that my colleagues from Halifax Needham and Halifax Chebucto have spoken on these very needs of how one is prepared to how the legislation should assist those individuals and protecting them. I think the most single important part of this piece of legislation that we have difficulty with is what are the rights of persons with mental disorders. And I do know that we have people in our political party on this side of the legislative floor who are paramedics, who are often called, with respect to addressing some very serious problems around individuals with mental health issues and mental health orders. And I do say to the member of Sackville-Cobequid, and I do know that member of Sackville-Cobequid will probably speak to this piece of legislation. If he doesn't speak to this piece of legislation tonight, Mr. Speaker, there will be another day, And I do know that the government is not interested in rushing this, that the government of the day is interested in listening to what we have to say on this side of the legislative floor and our concerns with this piece of legislation. He also knows that the member for Sackville-Cobequid, who in his past profession before coming here was a paramedic, knows the need for the resources. He also understands the need for the facilities, and he understands the need for the appropriate treatment that ought to be provided to persons with mental health disorders. We can talk about the quick fix there, and I'm certainly see this as a piece of legislation that gives some false hope to individuals, individual family members, individual guardians, people whom are the caregivers of persons with mental health disorders, who find it difficult to cope, think that this piece of legislation, the involuntary psychiatric treatment bill, will address the issue. Mr. Speaker, I want to say to you that that is not the way we do this in Nova Scotia. I certainly hope that we have learned because of past practices and past experiences, that we have learned how easy and how quickly it is to have people sign certificates. And if it's that easy without some checks and balances put in place, and I do know that there is a board, and I do know that there's a patients' rights advocacy group, but I, along with my colleague who has stated earlier, how does that person reach the resources that are available to them once they're apprehended? Once they're, how are they going to reach those kind of resources that are available to them? The advocacy group. If they don't have a telephone number, and if they're in such condition that they don't even request that, then they will continue to be locked up until such time as someone comes by, signs a certificate, and then puts them into an institution. This is the kind of practice, Mr. Speaker, that hopefully a civilized society moves away from. We recognize the responsibility that is ours and the right to protect those individuals who are not able to help themselves. And I can't imagine to know or to understand the frustration of a family member who has an individual with mental health disorders. I can't imagine, and I don't profess to know the experiences that family might have. But I do know that when frustration sets in, the total need and the cry for help comes, that there has to be a government agency or organization that comes to the rescue and helps that family, rather than just simply putting the individual in an institution through an involuntary psychiatric treatment certificate. We have moved a long way from those days, Mr. Speaker. And I do know, Mr. Speaker, in your former career, before coming to this legislative assembly as a police officer, that you might have very well had to address some very, very important issues and serious issues around persons with mental health disorders. You know that often the case is that the individuals in question have not taken their treatments. And for some apparent reason, because they have not taken their medical treatments or have not had the supervised personnel to assist them in taking those treatments, get into trouble. And it's often when they get into trouble that all of a sudden the bells start ringing and someone wants to do something about it. I would say to you that your government has an opportunity to look at this bill and think about the consequences of this piece piece of legislation. I have a major concern as well, Mr. Speaker, with this piece of legislation and the infringements upon one's individual rights. I don't know if this piece of legislation in itself, in fact, is a violation of the Charter of Rights. I don't know, Mr. Speaker. I hope I will know that when it crosses this floor and into the Red Room and people talk about this piece of legislation. But if this piece of legislation does impede upon the rights of individuals through the Charter, then we need to know, and we need to know how it might. I've listened to my colleague from Halifax, Shabaktu, who was a participant in, I believe he had stated, crafting some of the Ontario legislation around the Mental Health Act. I've listened to my learned colleague on the issue of the rights of individuals, and his speaking of Mr. Alan Borovoy.
Order, please.
Whom, in fact, was...
Order, please. There's too much noise in the chamber. Let's ask members to take their conversations outside if they have to talk, please. Thank you. Young member Dartmouth North.
Thank you, Mr. Speaker. And as I was starting to comment with respect to the rights of individuals, we need to know that there's a guarantee, there is a protection of every right of every individual in this province, and that includes the individuals with mental health disorders. I want to say that I want to go back, Mr. Speaker, to the real problem here. And the real problem here, as I see it, and I do believe that my colleague from Halifax, Needham, had touched on it. And there are three issues that has actually prompted this bill, and this bill probably would not be in the legislature in its context if it weren't for the government's lack of addressing the issue of wait times, the lack of facilities, and the lack of resources that are needed to address the issue of mental health disorders in this province. I want to go back to the very real issue of small options homes. This was intended to provide services to individuals with mental health disorders in a community setting. It would allow mental health patients to come out of institutions, live in the communities, be a part of the communities, and also have the expertise that would be provided to them. There would be the professionals in those small options homes who would have the professional experience to provide the proper needs. For example, the dosage of medication, the needs to keep their medical appointments, the needs to assist them in reintegrating back into the community. All these needs. Now we find, Mr. Speaker, that we have actually frozen that service to the individual. Not only have we frozen the number of beds and the bed services in small options homes, but we have also decreased the amount of supervised housing units or supervised apartments where people can go in with the expertise again and receive that expertise service. I happen to tell you that I was surprised when the minister who had made some acknowledgement, the Minister of Community Services had made some acknowledgement that in fact there was a need for a freeze on the moratorium of small options homes and supervised apartments. However, that they were going to look at that and move back into providing those services to persons in need. And I do say that this very action has contributed to the problem of mental health services. This is but one service that has been available to mental health consumers across this province, Mr. Speaker. But it was the service that was the initial services that would at least be the start of providing additional services. There has been some talk that there has been some new money added into the budget so that the Minister of Health can provide additional financial resources to programs and services that will assist mental health consumers. I certainly hope that is not the reason our third party and the legislature is supporting this piece of legislation.
Order, please. Because of the late hour, the honourable member would like to move adjournment debate, please.
Thank you, Mr. Speaker. I will now move the adjournment of the debate.
Motion is to adjourn debate. Is it agreed? Agreed. All those in favour say aye. Counterminded nay. The motion is carried. Call upon the actually, there's a request. The Honourable Government House Leader.
Consent of the House, like to return to the order of business reports of committees.
Is it agreed?
Agreed.
Agreed. Reports of committees. The Honourable Minister of Justice.
Thank you, Mr. Speaker. Mr. Speaker, as Chairman of the Law Amendments Committee, I am directed to report that the committee has met and considered the following bill. Bill number 198, an act respecting the Halifax Bridge Commission. Bill number 210, an act to amend Chapter 6 of the Acts of 2000, the Health Authorities Act. The committee recommends these bills to the favorable consideration of the House with certain amendments.
Those bills refer to the committee. Full House on bills. Now, Minister of Justice.
Thank you. Mr. Speaker, as Chairman of the Committee on Law Amendments, I'm directed to report that the committee has met and considered the following bills. Bill 192, an act to establish a day to recognize Alexander Graham Bell. Bill number 205, an act to amend Chapter 418 of the Revised Statutes 1989, the Securities Act. Bill number 206, an act to repeal Chapter 2 of the Acts of 1987, the Camp Hill Foundation Act, and Chapter 492 of the Revised Statutes 1989, the Victoria General Hospital Foundation Act. The committee recommends these bills to the favorable consideration of the House with certain amendments.
Will these bills be referred to committee and the whole House on bills? Honourable Minister of Justice.
Mr. Speaker, as Chairman of the Committee on Law Amendments, I am directed to report that the committee has met and considered the following bills. Bill number 174, an act to amend Chapter 28 of the Revised Statutes 1989, the Auditor General Act. Bill number 180, an act to amend Chapter 18 of the Acts of 1998, the Municipal Government Act. Bill number 191, an act to amend Chapter 223 of the Revised Statutes 1989, the Assessment Act, Chapter 18 of the Acts of 1998, the Municipal Government Act, and certain related statutes. Bill number 208, an act to amend Chapter 10 of the Acts of 94-95, the Workers' Compensation Act. The committee recommends these bills to the favorable consideration of the House without amendment.
Will these bills be referred to committee and the whole House on bills? The Honourable Minister of Justice.
Mr. Speaker, as Chairman of the Committee of Law Amendments Committee, I am further directed to report that the committee has met and considered the following bills. Bill number 177, an act respecting certain financial measures. Bill number 202, an act to amend Chapter 5 of the Acts of 1990, the Children and Family Services Act. And Bill number 207, an act to amend Chapter 365 of the Revised Statutes 1989, the Provincial Finance Act. The committee recommends these bills to the favorable consideration of the House with certain amendments.
Will these bills be referred to committee and the whole House on bills? Obviously, the members of the Law Amendments Committee have been working very hard today on behalf of the province of Nova Scotia. I want to congratulate them on behalf of the House. Now I'll call upon the honourable member for Cole Harbour Eastern passage on tomorrow's hours and order of business.
Thank you. Thank you, Mr. Speaker. Tomorrow the hours are from 2 p.m. to 6 p.m. And after the daily routine and question period, we will be calling Resolution 4077, which is on the regulation of gasoline prices and home heating oil prices, and Bill number 217, which is the Health Insurance Protection Act. And I do move adjournment of the House until tomorrow at 2 p.m.
Motion is the House adjourned to 2 p.m. Is it agreed? All those in favour say aye. Counterminded nay. Motion is carried. The House adjourned to 2 p.m.